4743. This is HS Financial Group versus Maryland Lawson. Matters before the court on the issuance of a subpoena. Your appearance for plaintiff in this matter.
Morning, Your Honor. Daniel Weberman, P76609, on behalf of the plaintiffs.
Thank you, counsel. I'm looking for Ms. Lawson, Maryland Lawson. If you're on the Zoom, please say something at this time. Maryland Lawson. Counsel, you've had any contact with Ms. Lawson, or she reached out to you in any kind of way, sir?
No, Your Honor, she has not.
All right, your pleasure at this time, counsel, and as much as it appears that the defendant has not appeared, looks like you did get service on the subpoena, and you also, well, check that. I see a petition or an order to show cause that I signed, setting the order to the motion to show cause for hearing on today's day. Right, counsel?
Yes, the show cause was personally served on Ms. Lawson on 9/12. So I request a bench warrant be issued.
All right, thank you, counsel. The court will issue a bench warrant at this time. What was the amount of the judgment in this matter, if you will, counsel?
The amount of the judgment was $2,486.
All right, the court set the bench warrant at $2,500 cash.
All right, thank you, Your Honor. I'll have that information submitted.
Thank you, counsel.
Thanks.
The court now calls case number 21. That's 156804. That's SMSE Federal Credit Union versus Alfonso McKay Jr. That is before the court on a petition and order to show cause. Your appearance for the plaintiff in this matter, please.
Yes, Ronald Scherf, CHERF, P23315.
All right, thank you, counsel. I'm looking now for Alfonso McKay. McKay, if you're on the Zoom anywhere, please say something at this time. All right, it looks like looking here for proof of service, counsel. Were you in fact able to serve the defendant in this regard?
Yes, we were, Your Honor. He was served on August 29th of this year at 2:30 p.m. And that was filed with the court on September 8th of this year, Your Honor.
All right, looks like it hasn't populated to this bit of a file that I have, but I will issue the bench warrant. Also, in the interim, I did receive a petition for partial payments, asking for the opportunity to pay at the rate of $50 a month. I was inclined to set that at $80 a month. Then I held back on that because I saw the show cause petition.
I've not received the paperwork, the petition that you're mentioning, Your Honor. I would also indicate to the court that our judgment was a claim and delivery judgment of for $9,614, plus for the delivery of a 2012 Ford Taurus, which the credit union has been unable to recover.
All right. Now, in these under these circumstances where the defendant has not appeared, the court will issue the bench warrant in this matter, and the total sum of the judgment, counsel.
$9,614.69.
Right, the court issue bench warrant $9,700 cash, and I'll sign that order upon presentment. So get give the bench warrant over to me, and I will sign it with the $9,700 cash bond.
Thank you, Your Honor.
The court now calls case number 22-180028. This is Beaumont Health versus Joanne Mack. Now, the matter is before the court, set on for a hearing. Looks like this is the first hearing regarding this matter. Counsel, your appearance at this time for plaintiff.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
All right, Madam Reporter, were you able to get that? There was some interruption somewhere.
No, Judge, the P number was, I didn't get it.
I'm sorry for the interruption, counsel. Your appearance at this time, sir.
Let me try that again. Am I echoing?
Yes, sir. You're good now.
P69068. Sorry.
Okay, I got it. Thank you.
All right, thank you. All right, now I'm looking for Joanne Mack. I see that you're there. Unmute yourself and say something to me.
Good morning.
Good morning to you, ma'am. All right, it looks like, as I indicated, this is the first hearing, and I think that the two of you had an opportunity to speak in a breakout room. Is that correct, Mr. Burke?
It is, Your Honor, and we did reach a resolution.
All right, very well. Is that correct, Ms. Mack? You've been able to get this resolved?
That is correct.
Go ahead, counsel, if you want to tell me about that. If you want.
Sure, Your Honor. Today, Ms. Mack will consent to a judgment for the full amount, which is with court costs, $696.81. She asked, and I agreed to $50 a month beginning October 11th. I'm going to prepare a consent judgment for her to review and sign, and I'm going to email that to her and then get it back to you if you'd allow maybe 20 days to do that, Your Honor.
All right. Ms. Mack, is that the agreement that you reached regarding this matter?
That is correct.
So the total judgment will be $696.81. You would commence paying on that October the 11th at $50 a month until the balance is satisfied. Is that correct?
Correct.
All right, and Mr. Burke puts that in a judgment form with that exact information. Would you have any objection to him emailing that to the court so that I can get it entered right away and you guys can move forward? That'd be okay with you?
That is okay with me.
So what he's going to do, he's going to initial on that. He's going to initial on that Joanne Mack, and it's going to say consent on the record. And then he's going to send it to me. I'll go ahead and sign it as long as it says what you guys agreed. I'll send it back to him, and you'll get a copy as well. That makes sense to you, ma'am?
That makes sense to me.
All right. Mr. Burke, do you have an email address to send it here, sir?
May I get that, Your Honor?
Yes,
Thank you.
sir. That's going to be Latifah, LATIFAH @3636ph districtcourt.org.
Got it. Thank you.
All right, so get that right over to me, and I'll get it all signed up, and then we'll get it distributed to the party.
Thank you, Your Honor.
Good day to you, Ms. Mack. Thank you.
Thank you.
Have a great day.
The court now calls case number 22-18-4955. This is Credit Acceptance Corporation versus Adipa Miller. Now, the matter is before the court set on for a scheduling conference. Looks like the court is here to receive defendant's answer regarding this matter. The claim in this matter alleges breach of contract with damages in the amount of $3,723.50. 15 cents plus court costs. Your appearance for the plaintiff in this matter, please.
Judge, may I please court? My name is Attorney Richard Bruce. I am the attorney of record for the plaintiff. I am the attorney of record for the plaintiff in this pretrial today.
All right, thank you, counsel, and good morning to you. I'm looking for Adipa Miller. Ms. Miller, Mr. Miller, if you're on this Zoom, any person living at the Marquette address in Detroit, if you're on the Zoom somewhere, please say something at this time. Counsel, I'm not getting a response. The answer that was filed in this matter has in the third page, I've spoke to make payment arrangements to pay $744 by August the 3rd of 2022 to the plaintiff credit acceptance. So has there been some exchange or update, what you know about any of that, sir?
Judge, may I please court? Richard Bruce of the record. I can tell you, Judge, that looking at my electronic notes in this file, defendant did reach out to us and she made a proposal for a settlement. I confirmed that in writing, which I signed a letter to her. Judge, I can tell you that the settlement of $704.63 is not due to be paid pursuant to the agreement of the parties until November 28th of 2022. That being the case, Judge, I'm a little reluctant to ask for a default today. And I would ask you to, well, in your discretion, to maybe continue this pretrial until, let's see, November 28th is a Monday, perhaps to the first week of December. I see December 1 is a Thursday.
All right, that makes sense to me, Mr. Bruce, and I think the more reasonable thing to do, given that there is, the defendant has reached out and there's some attempt to get it resolved, that'd be worthwhile to allow that to run its course. I will set it over for December 1, and I'm going to set it for a review on that date. And we'll address any other issues that need to be addressed to the extent that the matter is not resolved as the defendant has wished it.
Yeah, thank you, Judge. Will that be at 9:30 again?
I'll go ahead and set it at 9:30 a.m. Mr. Bruce.
That'd be
Thank you,
good. That'd be great.
Before that, that's good call to adjourn. The court calls case number 22-185-078. This is Metro Durable Medical Supply and First Medical Group versus Geico. I've been given the company. The matter is before the court. Looks like we're set on for a general hearing, a status conference, if you will. It's maybe the first hearing regarding this matter. For the plaintiff, your appearance at this time.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff.
Right. In this authority, I see Metro Durable and First Medical Group. Is that, those are two separate entities, or?
They are two separate entities, and I'm appearing on behalf of both of them, Your Honor. Hang on one moment. Yes, Your Honor. We're representing both First Medical and Metro.
All right, thank you, counsel. For defendant in this matter, you may at this time, please.
Good morning, Your Honor. Michael Fox, P75553, on behalf of defendant Geico.
Thank you, Mr. Fox, and good morning to you, sir. I do see that the matter has been properly joined to answer the affirmative defenses, and a demand for jury has been submitted in this matter. As the parties, I know it's kind of early, parties talked at all about the way forward. I'm inclined, of course, to go ahead and set up something of a scheduling order. But have you talked about how close you are, how far you are, that kind of thing?
We have not yet spoken, Your Honor. I have not yet had an opportunity to speak with Mr. Fox. I think he filed his answer maybe about a month ago, if that's right, Mr. Fox. So this is a relatively new case. But I leave this to Mr. Fox, but perhaps we can just get a scheduling order, and then we'll speak with each other before the next pretrial conference.
I would agree with that, Judge. Yeah, if I could have some time for discovery, there's some questions I have, and I don't really have much to go on at this point to present anything to my client.
Sounds good. And by the way, I have the answers, answer affirmative defenses and items along that line filed with the court back in June. So it's been several months. I hate that it's with the volume of stuff that we have at the hearings tend to get set out as far as they do initially. But anyway, we'll go ahead now and grant a formal order of discovery. I want to take a look at the matter after 60 days. So I'm going to give it a 60-day discovery order. If the parties after that time have worked on this and feel that you need some additional time, I certainly would be inclined to grant the same. So discovery be open until the next trial date, straight at the next pre-trial date. That's
October 31st.
31st.
Mhm.
They're giving us.
You want 60 days, right?
I want 60.
Well, the 26th.
November.
Oh, November. Geez, I'm looking at October. You're right. October 28th, yes.
November 28th.
Yes, November
Do that. All right, November 28th.
I'm looking-
Will be the next action date on this matter. And that discovery is open through that date. And we'll take up the matter then. If there's other things that are needed, I will address those at that time. Under provision 6 of the scheduling order that you will receive in the mail, it will have a provision that allows you to file motions dispositive or otherwise that you wish to file and bring before the court. Should something come up in this short window and you want to have it brought before the court, you can file your motion and set it for hearing on the 28th. I'm sorry to keep it all this in order. On the 28th of November. And all you need to do is make sure that you give 10 days notice to the other side regarding your motion. So even if it's a motion for summary disposition, under my order, the rules are short. If you file that motion, as long as you give the other side, the opposing party, at least 10 days to respond to the motion, I will hear it on the 28th of November. Again, this does not prevent you from filing motions perhaps in the future, but if the case seems to be coming together during the discovery process and you have something you want to drill down on, then go ahead and file that motion, give the other party 10 days to respond and set it for hearing on the 28th so we can make that day a useful day if there are some things that should be resolved at that time. All right, so you'll get that order from me in the mail. Other issues of exchange of witnesses, those are not being addressed at this time, as I'll visit this matter in about 60 days. All right,
Very good. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Good day to you. That time on that, by the way, is going to be 9:45 a.m. 9:45 a.m. All of that will be in the order that you'll receive. You'll have the date and time, also the information regarding the stuff. All right, good day to you.
Thank you.
Thank you, Your Honor.
The court now calls case number 21-55805. This is Jefferson Capital Systems versus Wilma Clark. The matter is before the court on a petition for installment payments. All right. For the plaintiff, Jefferson Capital.
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff, P74229. And I'm sorry, Your Honor, I believe there's a motion to set aside a default judgment that was scheduled.
No, did I say that? Well, look what I have. It looks like what I have is a motion. Yeah, motion to set aside default. But I'm looking at the form and it misstated that there's a motion for installments. That's why I said. All right, the notice has motion for installments. In any event, yeah, it is a motion to set aside a default. I did take that motion under advisement and set it on for hearing on today's day. Thank you, counsel. Do I have Ms. Clark on the Zoom?
Yes, sir. Good morning, Judge.
Good morning to you, Ms. Clark. And Ms. Clark, this is your motion to set aside a default judgment that was entered in 2020. I don't have the full file in front of me. Hold on a second. I also saw with that packet a petition for installment payments. And then I saw a motion to set aside default and also a petition for installment. Tell me about objections. Tell me about the reasons you believe that the judgment should be set aside.
I did,
Clark? Sounds like something's going on with your device there. Do you have more than one device or what, ma'am?
no, I'm sorry, I was having trouble with my laptop. I'm on my phone.
Okay, so yeah, tell me, why do you think that the judgment should be set aside, ma'am?
I was before your honorable judge back in April about this case. I had, at that time, I put a motion in to set aside the garnishment, but I unbeknownst to me, it was past the garnishment stage. It had already been judgment. So your honorable judge, you informed me that I needed to go to have the judgment set aside. So that was April of this year, and I put a motion in for that. And I also, meanwhile, I made arrangements to do installment, and your honorable judge agreed to a certain installment, but I thought that the money was going to come out of my check, like the garnishment money was coming out. Not knowing the law, I didn't.
You ready to rotate?
So I didn't.
I can't hear you now. So you didn't make payments under the installment order, correct? So Ms. Clark, you did make those payments? Can't hear you.
Judge hearing was allowed. I was just waiting for the judgment hearing, so I can explain the case.
Yeah, but
And that. Pardon me?
Did you make the voluntary payments?
No, I personally didn't make any voluntary payments after it started. It was about a week, and they put it to set aside the judgment. I mean, set aside the garnishment. I thought it was going to be coming out my check like it was before with the garnishment. I didn't know that once arrangements had been made that I had to pay it out myself. So as soon as I found out, then they had already put a motion in to disregard the agreement. So I went the next day and I put in. I tried to explain that I didn't know that I was supposed to pay out my money, pay directly. That it was not going to be coming out my check like the garnishment did. Not being privy. I just didn't know the law.
Yeah. All right, ma'am. So tell me why should I set this judgment aside? Why do you think the judgment should be set aside?
Well, at the time those bills occurred with DTE Energy, I did not own the house anymore. The people that owned the house, it was on them. It was in 2015. I sold the house to them. They were some relatives. I sold the house to them, so it wasn't my bill. And they, I wasn't living there, and I didn't accumulate that bill. But they were aware of it. They let me know that and I did get as the owner of the property, I did get some information about the bill, and I talked to them. They said they were going to take care of it, and I hadn't heard anything else. I hadn't heard anything else until all of a sudden this garnishment came. That's been since 15.
All right, ma'am. All right.
I hadn't heard. I hadn't got any paperwork, Your Honor.
All right, ma'am. Let me hear from you, Madam Councilman Francis.
Your Honor, as far as the installment payment, the court had entered the installment payment back in April. We did send the defendant a letter and provided her an opportunity to make up those payments, which she failed to do. That was back in June. And the payment plan wasn't set aside, I believe, until July. So she did have sufficient opportunity to make up those payments. As far as the motion to set aside the default judgment, Your Honor, the judgment was entered back in October of 2020. The defendant was served. She's failed to set forth any good cause or meritorious defense. She was aware of this judgment. As she indicated back in March, she filed an objection to a tax and wage garnishment, which Your Honor denied. She then filed her motion for installments in April, which payment she failed to make. There is currently a garnishment in place, and I believe that's why she's filed the instant motion for another payment plan. So at this point, Your Honor, I would ask that both her motion for installment payments be denied, given that she had failed to make any payments on the previous installment order, and that her motion to set aside the judgment also be denied.
Are you receiving, has the plaintiff received payments under the garnishment recently?
The last payment that was received, Your Honor, was received on September 13th.
How much was that payment?
No, a payment came out this past Friday.
Ma'am, I haven't come to you yet. I'm Madam Counsel.
Oh, I'm sorry.
Sorry, Judge, I didn't catch that. Did you ask how much was the last payment?
Yes.
Okay, it was $249.74.
All right. Thank you, Counsel. Ms. Clark, you had something to say, ma'am?
Well, I was gonna say, I just got paid this past Friday, and another $244 came out. But the reason why.
Wilma, you got the gate?
The reason I want to do the installment, you set aside, because I had the property, the deed for the property and everything. It's showing that I didn't own the property back in 2015 when this occurred. And then I own it. I was not served. I've never gotten any paperwork from them. I've never signed any papers or got any.
All right, ma'am.
I didn't get the papers. The only papers I got was when the garnishment was due. Then I got that because it was my job. But I don't know anything. You know, I thought this was all cleared up because I wasn't the owner of the property then when it happened, Your Honor.
All right, thank you, ma'am.
And I have papers, my deed and everything, where it shows I didn't own the property.
All right, thank you, ma'am. You said it 4 times now. I've listened to the argument on the motion to set aside the judgment that was entered by default in this matter. And I'm more persuaded now by the statements made by Ms. Clark that the judgment is proper and remains in place. The fact that she did not own the property any longer and that she allowed family members to reside in the property, and that she was aware there was a continuing bill that was there. That's Ms. Clark's obligation. If there are persons that used her name or used the utility in her name, then her relief would be to go after them to recover what she has to pay to capital in this regard that relates to a DTE bill. This is a situation where she sold the property or gave the property to family members. They remained in the property and the utility remained on. It would have been Ms. Clark's responsibility to call and make contact and to have the utility shut off. When she didn't do that, the bill continued to accrue, and that bill becomes her responsibility, although she can sue the persons that were living there to collect from them, but she has an obligation to DTE and their successor, Jefferson Capital. I don't find that there has been a showing of good cause, nor is there a meritorious defense regarding this matter. Good cause as to why there was a delay, and meritorious defense establishing that she would have a defense to this matter should the court set it aside. As to the issue of not being notified regarding this matter, the file reflects that service was made personally, and then I have a problem believing that Ms. Clark did not receive the notification regarding this case because she's used the same address consistently, the same address where the service was made, and then in addition to that, Ms. Clark has indicated that when she filed a motion and she got an order from this court that stopped the garnishment and allowed her the partial payments, that she didn't understand that she was supposed to make those payments on her own. And for months and months, she never made the payments. I've further been notified that the plaintiff reached out to her to try and make up on those payments, and she never did that. I don't find, I can't find any basis for setting the default aside. There's no lawful or factual basis for setting it aside, and the judgment will remain in place. At this point, I'm not persuaded that defendant will pay on the judgment voluntarily, although the court offered her that form of relief at an earlier time. She did not take advantage of that. And so now she is under garnishment, and I'm not persuaded that she will pay voluntarily. So I'll deny the motion for partial payments at this time and allow the garnishment to remain in place. All right, that's my order. Good day.
Thank you, Judge.
All right, the court calls case number 22-185-305. This is Fox Point Town Homes versus Jacqueline Lindsay. The matter is before the court, set on for a status conference. Court is in receipt of defendant's answer regarding this matter. Your appearance for the plaintiff at this time.
Good morning, Your Honor. Alexander Popov appearing on behalf of plaintiff P 84378.
Thank you, counsel. Good morning to you. For defendant in this matter, do I have Jacqueline Lindsay or anyone appearing for her?
Yes, Your Honor. Nick Balberman, P 35262, appearing for the defendant.
All right, thank you, counsel, and good morning to you, sir.
Good morning.
All right, so I don't have much of a file here with me today. It looks like the answer populated, but in the file is somewhere separate from where the answer is. So I see that the claim in this matter is for approximately $9,500. Have the two of you talked about this at all in terms of whether or not there might be some room to find a way forward here?
Yeah, Your Honor, Mr. Balberman and I did speak in the breakout room. There's actually, we're here on behalf of other attorneys today as well. And there's been some prior discussions on possible settlements. Today, all that we would ask for is maybe a scheduling order for discovery and some motion dates. And hopefully by then, we'll be able to reach some type of settlement agreement.
I concur with that, Your Honor.
Very well. All right, so I'm going to go ahead and set you over for the 1st of November. And
I thought you said December.
oh, the 1st of December. I'm going to set you over for the 1st of December, if you will, and allow discovery to continue through that date. That date is also going to be the next hearing date, and it will be set as a pretrial. At this point, I'm not going to set dates for exchange of witness lists and things along those lines. I'll address those issues on the 1st of December. What I will allow is I will allow the parties to engage in open discovery through that date, and also to file any motion that you might wish to have heard before this court, and to set that motion for hearing on December the 1st. That can be dispositive or non-dispositive. The only requirement is that you allow the opposing party at least 10 days notice before the hearing. So if you file a motion, something comes up, whether it's for discovery issues or if you think that you have enough and want to file a motion for summary disposition, you could file that. Just give the other side 10 days to respond, set it for hearing on the 1st of December. I will hear it on that date. That will be under paragraph number 6 in my schedule for it, and you'll receive that in the mail in the next couple of days. That hearing time is going to be 10 o'clock a.m. On December the 1st.
Thank you, Your Honor.
Thank you, gentlemen. I wish you well.
Thank you, Your Honor.